They say technology makes our lives easier. For work, to learn, to travel, to communicate. But there are things that machines cannot yet do. Things as important as engaging, putting themselves in your shoes, having intuition, or making intelligent decisions. In an increasingly technological world, we need professionals who provide intelligent solutions based on their know-how. Because there are things that technology cannot yet do for you. The human tech.
Good afternoon, everyone. Thank you very much for joining us today in September 2024. Today, we're going to talk about a hot topic about the touristic license. And because in this community has been recently updated and changed. And obviously, there is a lot of questions, a lot of demand on what to do, what not to do. Please send us your questions through the chat that you have here on your right-hand side. And we could try to answer as much as we can, as much as we know. And obviously, according to the only law that we have in our hands, which is the one published on the 4th of August. I've got in the panel today, Pedro Heredia. Hello, Pedro, can you hear me?
Hola, Ignacio, hello. I can hear you, I can listen to you very well.
Hey, right, we're back from the summertime, Pedro, and ready to talk about this hot topic that I know you've been inundated about questions.
Yes, it is.
And over to you, Pedro, yes.
Well, it is actually, I mean, obviously it's been approved in summertime, and the 7th of August to be started in the following day, which is the 8th of August, which is very brand new. And obviously it's affecting a big industry that we have in Comunidad Valenciana. In the notes, beginning of this modification of a law, it says it is around 16% of a Producto Interior Bruto, which is the turnover really of a community, Valencia community. Well, 16% is quite high, it's quite big, and it's being increased 160%. This is what it says in this specific modification of law. 160% from 2015 to 2023, which means that the industry of tourism, obviously, with this new regulation, with this amendment of some other regulations, because this decree, what makes is to change some articles of 3 main rules that we have. I will put it in the chat what is changed, really. Let me just check here. Panelistas in todos. Really, what is changed is 3 laws. So this new decree, we are going to talk about this new decree that changed some articles of this law. But what really is doing it is elevating, is increasing the standards for the requirements, is increasing, and obviously increasing the limitations in order to acquire the license in order to have an apartment, a property for touristic use, which means that obviously it's been a lot of issues, a lot of, I would say, fraud. People who was doing it without a license or with license bodies. It was not, the information that was given in the license was not perfect, or was not correct according to the property that it was given. So with this, it's going to be eliminated. There are big fines on this. And obviously there is some period of time in order to adapt, but what it makes really is to increase the standards in order to obviously to do it properly. And why this has been done, because obviously the hotels industry is been pushing about this situation in order to say, well, we are incompetence. Okay, hotels, they say we need to do a lot of things, a lot of adaptation, a lot of emergency, a lot of situation where we need to adapt on the rules. And those apartments or properties for touristic use, they do not. So with this, it's going to increase. In some way, it's going to be a fair competence in some way. But obviously it's going to be done, because some property will not be able to be included in this situation in the following years. And this is a transition period also in the following years for those properties that is being already inscribed in the tourism registry. But I personally think it's good what has been done. I personally think is good in order to obligate to owners to have higher standards of service and higher standards of properties in order to be used by tourism. So we increase the quality of the service, and obviously will be increased in some way the price. Probably the offer will be increasing more and more. This is not going to be decreased with this. When I mean limitation, we means there were limitations to acquire, but obviously there will be a big market to invest and rent on these kind of situations. And the demand goes up, and it's every year is going up. Every year we think, okay, well, next year will not be more than this year, and it's happening. The following year is more. So the demand goes up. So at the end, those ones who have, and this is my personal opinion, those who have properties or touristic use, obviously, we have a big demand. Will be obviously you have to offer quality services, and at the end we'll be able to increase these prices on risk according to the rule offer and demand, obviously. But I think Ignacio, it's good that it's been done. Let's see, because also we are learning about these changes it's been done. Let's see what are the questions, because I hope that we can answer some of them. And obviously we will be reading the law while we are making this webinar. As I said, we are also learning about this. But I don't know, Ignacio, what you say, but I think it's not been bad what has been done. Probably it's been done very urgent from one day to another one, but it's something that probably the industry needed.
Right, Pedro. Okay, basically, we've been studying the law here, and obviously we could say as much as we could go, as far as we could go. I agree with your comments. I think it is a law to protect high quality standards for touristic apartments, pretty much probably because the hotels are providing X amount of quality here, and the apartments probably are not. And what they're doing here, the key of the law, Pedro, I think here, they did establish, they draw a line on the 10 days. This is for me, the structure of the law. Say less than 10 days, more than 11 days, right? So now is a model where you as an owner of a property need to choose whether you want to apply, if you never apply for the license, for a touristic license, then we need to face whether the town hall allows you to do that, whether your community does increase the price because of that, or does prohibit or does not prohibit that. And then you need to follow all the instructions that the law, obviously habitation license, so there is no illegal properties. You need to have compatible areas, so you are subject to the town hall to allow you to do that. Obviously, there is a minimum basic requirements of the standard of quality for this touristic license as well. And then we have in Pedro some questions here, like Raquel is saying, could I advertise in Airbnb periods? Well, Raquel, here the situation is, my understanding from the law is the key point is whether you are less than 10 or more than 10. Now, if you're going to do a mixture, which is what you're suggesting here, I think this could be very messy, because you will need to report the board that what periods you're going to be one type and one period you're not going to be the other type. The way you're saying here on your question is, could I get a reservation for more and something less? I find that very messy to follow the law. Okay, the way I feel here is, okay, are you already a touristic apartment with a license? Because obviously it's being granted, Pedro, correct me if I'm wrong, for more than 5 years. The one that they already have existing license, they could hold that license up to 5 years. Okay, that's if you have a license. If you don't have a license, you're subject then for the town hall to grant it or do not grant it. And Raquel is saying here whether we could do a mixture, which is where I find it difficult to organize as an owner, a property owner, because if you're getting a reservation for more, well, it's not allowed, Raquel. I mean, Pedro, correct me if I'm wrong.
Yeah,
if you are a touristic, you're not allowed to get more.
It's a good question to be made by Raquel. And well, the law is changed on this about this rule about it's 10 days. What it says in any case, it's a presumption that exists touristic intention. Also exists touristic intention for using the property as a touristic use. When, and it says, I think it's the first one or the second point, it says, when the property is offered to it's like utiliza la palabra es comercialización turística, is like a tourism commercialization on a channel, which means, for example, it's kind of a new technologies, Airbnb or booking all this. So in any case, the property will be considered as a touristic use if it's offered in a touristic channel. So if in any case it's done in this way, I personally, this is what I think. I personally think that it couldn't be able for more than 11 days. So if you do it more than 11 days, I understand it's breaching the law. And then it says, in this specific article, it says, and then will not be considered at all. So those properties are rented equally or more than 11 days with the same tenant. So I think, even though, and I agree with you, because when I read the law, I was like, I made the same question to myself, and I think I can answer it in this way, but because it says literally, it is a presumption that the use that you're doing is for touristic. So it means that if you do it in that way and can be done in that way for these technology channels like Airbnb, it's a presumption that is a touristic use. So to break the presumption, you need to say it that it's a temporary contrato temporada. It's like a different way with a different service on that.
But Pedro, probably on Airbnb and booking, you can only rent from 11 days. So if you and me are trying to book through the internet and the inspector is trying to book it, they will say they're not allowed, and there's a minimum requirement of 11 days to book it through this channel. So this breaches the presumption that you are already declaring on the channel that you do not accept that. Now, if you do accept less, you need to have the license. And the question that Raquel was saying, how about if somebody wants to come for 15 days? Technically, with that license, you are not allowed to do different type of business unless you inform the platform, well, you inform the history, the registry, that in this period, you're going to do something different. So I think, Raquel, the straight answer that we could get you from the reading of the law is that you will need to report what period of time you're going to do one type of business or the other one. I don't see what your question is saying here. I don't see how much, I mean, you could change it on a daily basis. Now I change it. Now I don't change it. I don't see that, Pedro. I don't know what you think, but I think this got to be very solid business.
The law doesn't say how many times. I mean, I think someone has also asked that. I have attached to everyone the link in order to this specific proceeding to do that. But I mean, I think it's a very good question. About, I mean, one of my main topics are really on this new decree is about the 10 days issue. Okay, well, let's go to.
But it's a good point, Pedro. It's a good point because I think most of the hosts from Airbnb are going to have this question or booking because they're doing all types. In the old days, they used to have a model where it's 5 days, 6 days, 10 days. Well, now I really think, Raquel, that we need to make up our mind whether we want to be in one side or the other. Now, if you want to do a mixture, probably my recommendation today is to draw a line in the calendar, what months you're going to do one business and what months another one. So I'm just suggesting July and August, touristic. The rest of the year, more than 11. I'm just putting here as an idea. Pedro, would you like to say something more about the law before we even go into more details about the questions? Because obviously we're having a lot of questions, etc. I mean, the bottom line, Pedro, is this is the big change nowadays. More than 10, less than 10, and the type of business that you're running and how you need to furnish your property and quality of the property. It is quite interesting, Pedro, what you said about not being able to use the keys in a box, and then you need to have 24-hour service.
The box located in a public way, in a street.
Pedro, you mentioned lately on the radio as well that people had to have service 24 hours.
Yeah, it is mandatory right now to have a 24-hour service, direct line, telephone number. That's mandatory at this time.
And
I may think about examples like probably the ones who are doing it is clients. They may ask to contact you because the key is not open the box, or something is happening at 3 o'clock in the morning and is some emergency is happening in the property. So it has to be given a 24% telephone number to contact you.
Mm-hmm. Right. So first thing I will tell to the audience here, okay, you need to reflect and think what kind of business you're going to have and whether you comply. I don't know, Pedro, if you could copy and paste the requirements of this touristic, because it was quite interesting where you mentioned that you have to have 24 hours a service, then you had to have fridge, air conditioning, heating, all these things.
Obviously, there is an annex about this decrease in annex that is giving all the requirements that needs to be done, but it doesn't mean that has to be done today. You want to adapt on that in the following 5 years. It's something that must be done in some way in some time. Obviously, will have to be done if you want to adapt on this. And obviously, for those who are going to apply for a touristic license, obviously something that is, in my opinion, is going to be compulsory.
And Pedro, you mentioned as well that obviously you need to have evacuation, fire, emergency situation, obviously instructions for emergency, but you have to have a lift in case your property is more of 4 floors, correct?
Yeah, that's another issue on this is if the building is no more than 4 floors, it's not compulsory to have an elevator. But in case it's more than 4 floors, then it's compulsory to have a elevator.
And Pedro, you mentioned that the rooms are prohibited.
Yeah, so, I mean, the renting out as a tourism accommodation. We are talking about always about this. By individual rooms is forbidden. Cannot be done. I mean, this law
is touristic. You're talking about as touristic.
This law is something from 2000. I mean, this already was forbidden really in 2018, but maintained and confirms and regulates this and increase really the breach of doing this. So increase really the fines on this. On this situation. So really, this is very compulsory, is forbidden to rent rooms individually for tourism use, because can be rented without this kind of tourism use. I mean, because someone is working 2 months, 3 months, 6 months, you can rent out an individual room. That's also able and legal, no problem with that, but not through these channels, digital channels. And obviously, this cannot be done. I mean, absolutely not.
Right. Okay, because we having people here confused about could I rent it out and disconnect and connect. I think people are getting confused. What we're going to do, we're going to share with you the law for you to read it, to be able, obviously, to interpret. But it's not about publishing your property only in internet or in a portal. It is about the days. This is what I need to be very clear here. More than 11 days, is one type of short terms. And Raquel was saying, what kind of contract can we have that? Well, a simple contract, contrato de temporada, right? Which is para uso distinto de vivienda, right? And it doesn't applies with the long-term rental. So you could have a contract for long-term if you wish, or you could still use Booking or Airbnb for more than 11 days, but you don't need to comply with the requirements of the touristic apartment. You could have it, but you don't need to go through the paperwork. So for people who are getting confused, I would say, draw a line. If you have more than 11 days, you don't need the touristic license. Even though you comply, you don't need to apply for it. Less than 11 days, you must follow the instructions of the law. Now, for those who wants to do a mixture, then you need to identify what periods you want to do. One type, one period is another one. I don't see, Pedro, you getting a reservation for 12 and saying, I disconnect. And then I don't see that practical. I find it risky. It's not clear how obviously everybody's to do whatever they consider they have to do, but I think probably it's better to have a plan. July and August, I do this way. The other ones, I do a different way. This is my interpretation, but I could be wrong that you could be so quick on informing. And that's one of the questions, Pedro, we can make to the board. But I think, Pedro, the article says that you must inform what periods you're going to have one type of business or one type of business. So I don't think it's just you could do just jumping from one day to the other and say, I'm changing, because the infraction is they will deregister you in case of breach. And you probably do not want to jeopardize the license. I think this is the important, Pedro, is for people who wants to do the mixture. This is where the difficulty is. When you want to do more than 11, it's not an issue. You could do any platform you like. If you want to do less, it's not an issue. You comply with the law. It is about mixing. It's about mixing. You need to have, and you need to draw a plan. Don't you think that, Pedro?
Yeah. I think that's the key point. Obviously, one of the main issues on this law. Let's go to another about the cadastral right now. Reading about the cadastral reference. I had an appointment last week, really, with some clients regarding a cadastral reference, because it happens that some properties are the building or properties that have a villa or has a different entries, and really is build it in a way that is different properties in the same property. But also we've seen situations where there is an apartment or a flat that really has a different entries on that, or once your entries has a different entries in that flat. So it really has two properties in one property, or more than one property, or more than two properties in one property, or in a building where there are like 8 flats, but at the beginning was just one registry number and has one reference or cadastral reference number. Which means right now this law what says is, okay, that cannot happen again. I mean, that each property which is offered must have its individual reference, which means that in case that this is not done, should be done in a public deed, in a notary, in order to divide correctly in the property registry and in the cadastral registry, individualize the property as different. I mean, the problem with the community of owners is really difficult, or I would say impossible, because you need really the approval of everyone, which is in many cases is really, really difficult. But those villas, those houses that has like 2 entrances or this, you need to put a division on that and says to divide that and say, well, this is really 2 properties instead of 1 is 2 properties. Obviously, the rules on doing that is there are some limitations. So what they are saying, the new law is saying, okay, you need to inform us about this cadastral reference before the 31st of December, which is very close. And if someone has right now property and it's just one reference, cadastral reference, just one, and has really different flats or different properties or different entrance, will not be on time to do that. Impossible to have this before that. But what also says, it says, okay, well, perfect. If you manage to do it and you enter in the property registry with a public deed that you have already divided on papers, then you will be given a code on the property registry, and then you will be able to give that this code, and you will have at least 1 more year in order to get this reference, this cadastral reference, a unique and individualized cadastral reference to give it to them. So it's important to do as soon as possible the division of the property into the properties that you are really renting it, in order to have this cadastral reference, and as a transition period, have it done in order to get a special code in order to inform as a transition period. That is extremely important with many, many properties. Okay, what else? One of the things obviously that should be checked and see how is the description or information that you have given to the tourism registry, because one of the articles says the inaccuracy, falsehood, or omission, or essential character, or any data, manifestation, or document that is accompanied or incorporated to a communication or responsible declaration, declaración responsable, which means that the inaccuracy of the information that you have given to the registry could give arguments to the tourism registry to cancel your license. So first thing that I will do is my license, the information I have given to the property registry, correct perfectly? There is no mistakes. I mean, voluntary mistakes, falsehood, omission, properly. I mean, that information needs to be done properly, adapted or updated in order to not to be able to get an inspection and be cancelled the license. Okay. And it says a modification or disappearance of the circumstances and requirements that gave rise to the inscription in the registry, which means that if you had some arguments to get the license, but those arguments of that property has changed, obviously, and will cancel the license if you are inspected, obviously. Okay, another issue really, Ignacio, if will be cancelled when the activity of the service has not been initiated. So you give the license after 2 months from the presentation of a responsible declaration. You have not done anything at all, that will be cancelled. Or when it's verified by the inspectors that you haven't had any activity at all in 1 year time. Okay, so if you have it, you need to use it. Okay.
This was another question that they're doing, Pedro. An interesting one that they do here, because of waiting to have the license. It's very difficult to answer this one. I'm applying for it, but I still didn't get it. Could I start renting it out this way? Well, technically, you don't have a license. Technically, you don't have a license. So if somebody denounces you, one of your neighbors or somebody, and you don't have a license, you could only say that you're in the procedure, but that doesn't mean that it has been accepted. So it's a risky one. I think they were asking about using the touristic and renting it out without the license because it's in process and it's taking 1.5 years. Obviously, you don't have the guarantee. You don't have the guarantee that they will grant it. And if somebody sues you and makes a complaint, the reality is you don't have a license. That's the truth. You know, how aggressive this community is going to be against these people, probably they might be overwhelmed. But I was saying to Pedro here on the radio lately that that as simple as somebody complaining to the consumers board or the town hall, they will send the policeman, they will make a report, they will ask you for the license. You don't have the license. Yeah, it's in process, but you don't have the license, so you cannot trade like that. That's technically, with the law in the hand, that's what I could say. Now it's up to everyone to make whatever they consider they should do. But this is Pedro, probably my interpretation. And Christina Knudsen here was asking as well if we are handling, Pedro, all these applications. If are we applying? I mean, we're applying for a touristic license for a lot of our clients. So yes, Christina, we have a lot of experience on applying for it. But please bear in mind, this is now an end from the 4th of August, and now starts a new chapter, right? And every town hall will be different, okay? Pedro, you want to carry on with a lot of questions?
Yeah, let's carry on with the, I mean, let me just check what I stopped. Just
we could answer, if we could just follow up all of them.
The main issues, I mean, because I don't want to forget the main issues or main issues that has been amended. What if I buy a property? What if I buy a property that has a touristic license? Well, at this time, in case of transfer or ownership of a property, when you buy a property, that enables you to have this activity, it will be necessary for the new owner to present this responsible declaration. And we call it compatibility urbanistic, as like development compatibility and the responsible declaration, in order to apply for this license. So whoever is going to buy a property and has a license, okay, needs to be transfer that, because right now the licenses are registered before the up to the 7th of August this year, have at least another 5 years, so until the 8th of August 2029, the 5 years. So, but if you transfer and for some reason the area or the place or the property, or for any reason the planning law didn't really adapt it to that, even though you got the license, to transfer that, I mean, you buy a property, it's better you to do a due diligence to check that the license that it was got by that property is correct according to the planning rules, according to the status of a community, for example, because this may be cancelled, even though you buy with a license and they transfer, and you say, well, I want to transfer this license to my name. Perfect. But the rules of planning is not correct, so the license will not be given. So it's something that in the due diligence, whenever you buy a property, because one of the issues is that license is currently given and the rules that are given has not changed. Well, that is something that is I think is important and has changed also in this law. One thing that has been I will copy, and one thing that has been given good also, these responsible declarations in order to, well, and the compatibilidad urbanística, certificados de compatibilidad urbanística, which is the development certifications, in order to substitute really the municipalities, it takes months and months. Sometimes in the south area of Alicante, I heard it was like around 6 or 7 months. So it is possible to do with some other entities. Let me just type on which, as it says, and I translated it into English. And
I think I copied, Pedro. I think I did copy.
Yes, ECUB. This is a collaboration entities and administration. So those companies that will be included in this system will be able to make a compatibilidad urbanística and compatible development a lot faster. So when you buy a property with this is the main document that you need to get, and then the declaración responsable, and this will be, the process will be faster than was taking, because we have clients, Ignacio, that sometimes it took a lot of months, and they would wait and wait and wait. With this system, it looks like it's going to be a lot faster.
Just for people to know our experience, first you need to apply for the compatible certificate from the town hall. Okay, so once it's been accepted that your area is acceptable for touristic, then you need to submit the petition, okay, with all the documents, okay, all of the documents required to fulfill the law. So it's 2 stages for those who never did apply for it. One is apply, well, some town halls are already informed that they have suspended all the license, the new license. So first thing you need to identify is what town hall we talking about. Second, whether they're gonna issuing license. Then you need to apply for the compatible report from the town hall, whether that is compatible or not. Then you need to submit the petition with all the requirements of the law, and the property has to be legal. Okay.
And this is the issue that I was mentioning about this compatible development, is because there's another change, I think, on this, and this issue is a planning limitation to be made by the municipalities, by the governments of the town. And let me read what I wrote. It is the town and the city councils are authorized to introduce, based on reasons of general interest, which is subjected, obviously, in each town hall, introduce limitations regarding the maximum number of tourist homes per building, sector, area, or zone, which means sector, area, or zone, which means that, okay, I have a license and some sector or zone is going to be changed. Well, no problem, because I already had it before the 7th of August. I will have it for sure until the 8th of August 2029. But if I'm buying right now a property that has already a license before the 7th or the 8th of August, and I need to make a compatible development certification, and the municipality has changed that rule before I buy the property, then I will not get it back. I will not, the transfer ownership, the transfer of the license to me will not happen. So it's something that I repeat, that it's important that if you buy a property with a license and is one of the values of the property is because of that license, you need to check that has not changed the rules when it was given the license. Okay.
Pedro, I don't know if you did cover the fact of you having a property, selling to someone, someone inheriting that license, and now they want to change the name. Do you cover that, the changing of the name under
Yes,
this law?
that's right. I mean, the transfer of ownership of a property, it doesn't mean that it's automatically transfer the license of the use. You need to make the application. You need to submit the application. What is important, and the due diligence that your lawyer make, is that the rules by the municipality has not changed as it was given the license, or in a different way to say it, the license that is given or the property that you are buying adapts to the planning rules according to the municipality in order to be given the license, because it's going to be, it doesn't say it's a new application, but it looks like it's a new application, really. It is a compatibilidad urbanística certificado, so it really means that it's going to be able to apply again about that.
So in this case, Brian, the situation is, could I register it in my name? Yes, you need to apply, but when you ring the town hall, you need to ask whether in this town hall there is still issuing license for touristic or is being suspended. I'm not sure, Pedro, if it was Denia, the one that's been suspended.
Exactly, Denia for the Pia. There are some follow-up. I think there are some other ones that has changed a little bit. I don't know all of them. I mean, we need to check, but probably Googling it will be easy to check it. But because it's being given some power to the municipalities now in order to change because of an area, sector, because of a general interest. So it's very subjective. So some municipalities will do that for sure in order to stop, to limit the offer.
My recommendation here for you that probably are a bit lost and you want to do it yourself, the first thing is a town hall. So if you need an appointment with the architect of the town hall, with somebody from that urbanism area, for them to inform you to confirm what areas they're allowed and they're not allowed. Otherwise, alternatively, you could hire an architect engineer specialist on this and they could do the dealings. Because in one way or the other, you're going to need an architect drawing of a plan. So, Pedro, there is still the need of hiring an architect engineer here that he will do the maps and everything and the measuring and everything, declaración responsable, which you will need to fill in, because technically you will need to comply with that, and a surveyor, a technical, will have to say this is true. So you have two options here. I think the question came from Mark. One, ring the town hall. That's the easiest one. If they get back to you, if they give you an appointment. If not, just hire the services of a surveyor who will be able to tell you you're allowed, you're not allowed. But the easiest is a town hall. The town hall is the one who rules on the municipality where you have. Then what is compatible? Because if it's not compatible, the only option you have is rent it out for more than 11 days, as long as that property is correct. And you don't need to apply for the license. So the license is only for those who go from 1 day to 10 days, right? And for those who are going to do from 11 days onwards, you only need a simple contract, or you could still run it through the Airbnb or Booking. Obviously, as Pedro said, making sure that under inspection, you're not allowed to book for less than 11 days, because otherwise, as Pedro said, there is a presumption that because you are advertising in the website and everything, that you have an interest on a touristic, but you could always prove the opposite. Okay, so first, a compatible document from the town hall. 2, applying for the license, complying with the rules and regulations. Obviously, not all the properties are going to fit into this category, most of them, but obviously we'll need to be looking into a property that is fully legal, okay? And then with the requirements, pretty much, we were, as Pedro was saying, the annex here, we were talking about Pedro having proper electricity, refrigerator, heating, air conditioning, the maps, elevator in case of more of 4 floors, proper access, telephone for 24 hours, and then you have the hot water, emergency telephones, you have internet, unless there is no coverage, unless you have no sign, there is a requirement of that. Information about where is the health center, the closest health center, emergency telephones. It is prohibited to have the keys in a box. Okay. Well, in public road, Pedro. So that's the thing, Pedro. Is in public roads. Cleaning service, change of towels and things. I think it's quite comprehensive one, but this is only for those who are interested to do less than 10 days. Okay, and now for those who might be right in the middle, sometimes less than 10 days, sometimes more than 10 days, probably my first recommendation will be to try to draw up your business, and you need to focus and say where I'm heading, what kind of business I want to do. What do I want to do? 2 months this type, and it's more about schedule and about planning. Okay, July and August, I'm going to do only 1 week. Okay, then just fulfill this. Or no, I'm going to do the whole year 11. Okay, when you start doing a mixture, I really think it's going to be very messy. It's going to be very messy. Do you think that, Pedro?
Yeah, I mean, that key point is important. Let me point out one of the things before we enter run out of time. It's about properties that are included in a community of owners, which I would say mainly of them are included in a property of owners. When you apply for a license, when you have let's forget about those ones who have already inscribed the property, has already got the license on the tourism registry. So those ones, this is not compulsory, but those ones who are going to apply for that in the future have to bring or make a certification from the property registry on the status of the community saying that there is no any impossibility, there is no any forbidden situation on the community of owners that a property could have a license. Because it could happen that by the unanimity of owners, all of them, absolutely all of them, may approve the possibility that no property can apply for a license. This could be approved but must be approved by everyone, absolutely everyone. And so you need to make an effort and make a document to bring to the tourism registry, say, oh, I don't have any problem by the status of the community, I don't have any problem by the property registry, in order to get the license, because I'm allowed to do it by the community, really. And this is different from, because we had also one question regarding if it's legal to increase the 20% cost of the community to those ones who have a property which is used with a license. It is legal, but it has to be approved by the 3/5 of the owners. 3/5 means 3/5 of all the owners of the properties that belongs to that community. So it needs to be approved by 3/5. It means that those one who goes to the meeting, general meeting, and say obviously yes, we want to limit, or we want to increase the costs up to maximum 20% to those properties that has a license of tourism use, and but after that is approved like an acta, like document is sent to those ones that didn't appear, because in many general meetings, in my experience, there is a lot of properties owners that do not personally go, they just don't go. And so that document will be sent to them, and if in 30 days time they do not say anything at all, will be understood that they have a positive answer in order to increase up to maximum 20% of the costs to those properties that. So at this time right now it's happening in many communities that is increasing up to 20% this cost. But this is obviously not in this new decree, this is in the rental law. But it's something that always need to take to check. I'm talking about in case that you are buying a property as an investment in order to rent. Okay, Ignacio, I don't know.
Pedro, there is one question for those, Pedro, for those who had already a previous existing license. Do they follow? They're asking here. Do they follow the all license rules, or they need to follow these rules as well?
Sorry, I didn't understand. So,
yeah, the question that they're making is for those who already have an existing license. Do they follow the all license rules, or this is now from the 4th of August? Everybody needs to perform this.
From the 8th of August this year, those ones who are already a license will have a 5 years license until the 8th of August 2029. This Annex 3, which has all these minimal requirements, really we have to be adapted on that in the following 5 years in order to renew, because without that will not be renewed.
And Pedro, do you think they need to comply with the 11 days and more than 11?
That's for everyone.
That's for everyone.
For sure.
That's for everyone. Okay, so that's the answer here from I think it was from somebody here.
Someone says, will the owner of license number get a notice if the license is suspended? Yes. I mean, one of the rules also has been changed, is slightly changed, is regarding you need to give information about whoever company is managing with your property, or if you are doing it by yourself, who are the owners and owner, you need to inform about email, contact details in order to be informed about any notification. So, and it is supposed and it should be, because if you are not notified, it doesn't happen to. Once you are notified, you obviously will have a time in order to make some allegations on that, and obviously from the notification, that is whenever you are able to do that. But you should be informed.
Right. So I think we are having similar questions, Pedro. I think again, first piece of advice here: town hall. Town hall has the power and the team of architects to tell you whether your property is in an area will be allowed for touristic license. That's number one for your business. Number two is, I did copy the link here. I know it's in Spanish. Eventually we'll just translate it into English, but you've got it here, the very latest published law for you to know the requirements in case you need to update it. Okay, so in case you want to apply for that license, you need to comply with this. For example, I was reading now, you need to have air conditioning, at least in 2 places, living room and kitchen, areas, at least. For example, one of the requirements. So they're trying to bring the standard, high standard, for these purposes. Now, then you will apply for it. Unless it is being suspended, you will apply for that license. I might recommend you to hire the services of a surveyor, an architect engineer, or even a law firm that will represent you to do all these things. Okay, we do it, but there are many people that do that as well. Okay, if you are not able to do it yourself. And the key point here, back to the questions that we're getting over and over, is about, Pedro, the different type of business everybody used to have. They used to have 5 days. They used to have 20 days. I think now, unless I'm wrong, Pedro, I think everybody needs to be very clear what they want to focus on. And then plus, obviously, the tax declaration. We didn't talk about the tax today, but if you do long-term rental here, you've got an allowance on 60% of the net is tax-free. Okay, so you only tax on the 40% of the net, which is very attractive, but that's only for long-term rentals. Okay, for short-term rental or touristic, there is no allowances, so it's income minus expenses, and that's what you need to pay. If you are resident, you do it once a year in June. If you are non-resident, you do it once a year as a non-tax resident. It will be different whether you are European and whether you are not European. If you're European, you will need to pay the tax, non-European, 24% of the gross amount, and they don't allow you to put expenses on it. And if you are not European, you will pay 19% from the net. Okay, only a bit on the tax, even though probably this is not one of the main topics now, but this is something to consider as a business owner of a property. Pedro, any other more questions you want to target?
Let me answer to, because I was just checking with, I think it's a question made by, what about the reservation for the rest of the year that were already made, so, because there's a transition period really on this. Obviously, those one who are, even though it has a license, and right now it says those properties, for tourist use, that at the publication from the 8th of August on this regulation have been reset or contracted for a period equal to or greater than 11 days, will maintain the agreed rental period until its termination. Has been reserved or contracted. Okay, and after this done, then it will be subject to the 10 days rule. This is for, I think it's for Helen. I think it's Helen, the one who has that.
Right. Here is a question for Mark. Let me just give you a little bit of idea here. Touristic license, obviously, less than 10 days. Short terms or long terms, more than 10 days. Fine. What type of contract is being classified? Vivienda de uso distinto, para uso distinto de vivienda, which is a type of contract for short terms you could use with the law, but just for a specific, which is very strong, pretty much, and tenants do not have that many rights at the long-term rentals. Now, the law has two branches. Long-term, short-term. They don't do it this way. They do different type of use, like vivienda, which is property, long-term, or other users. Okay, right. That's something that you need to consider. So don't worry with the short terms about the tenant having the right to stay 5 years. That's the question I think Mark was saying. No, they're not allowed. They're not allowed. It's only on the long-term rental contract.
Yeah. Let me make one point to Mark. You will see many estate agents that they want to make like a long-term contract, but for 11 months, because they say, okay, we do it for 11 months. It doesn't be considered that it's a permanent home. So if it doesn't be considered as a permanent home, the tenants will not have a right to stay up to 5 years. That's wrong. That's absolutely wrong. Okay. So whenever tenant establish a property as a permanent home, which means that it stays as a permanent home, as a habitual residency, which in one of the presumption is obviously it has a contract, at least 1 year term. It obviously has the right to stay up to 5 years, obviously, with full with all the payments, everything correctly. But a long-term contract gives the tenants obviously the possibility to stay up to 5 years. But the tricky things that you may see by sellers or owners or agents, in most of the cases do not work. Okay.
Right. I don't know if there is any more current questions here. Pedro, do you want to mention anything else here? I think we were clear about less, more, short, and long term. So this will be the type of business that you could do from now onwards. I think is more about you making a decision, right? I find the difficult one is on the mixture. That will be the one. And it's saying a tenant having, I mean, the key of the contract for not being long term is, I mean, the long term is when you're habitual and main property and your intention is to stay to live in the property. Okay, it's all about the matter of proof, but I will understand that a 9-month contract.
This is about NSS about a 9-month contract. When someone has a contract with a 9-month contract, if the tenant is coming to the area where you live to rent the property because the work is going to be for 9 months, or some specific situation about life that must be 9 months because of one reason, and it shows you about that, well, will be 9 months and there will not be really a long-term contract. But if you do not show anything really, I mean, the tenant do not show anything, it's just a contract that says 9 months, and really the tenant has rented this property as a permanent home, really.
It's a matter of evidence, yeah.
Landlord has a very few possibilities, I would say almost nothing, to stop that, to prove that.
If it's contested, if the tenant contests the contract and say, listen, I'm here with my family, I've got children here, I have nowhere else to go. This was my only property, and it was a long-term contract. But Pedro, if you agree that it's only 9 months, and then they need to walk away because it's not the main property, they have another property. But it's about contesting, and the tenant could contest the contract and query and say, no, this contract was not this purpose, was the other. But we just ending there in a litigation issue here, which is one party says one thing and the other one says the other.
And we Ignacio and myself, we are barristers. We deal in the courts. So our vision really is in order to avoid obviously the litigation. And in these cases, we've seen many cases that people comes with that kind of contract that obviously the judges have a very clear criteria. Obviously, it needs to be proved. This is like in a courtroom, but I would say it is if it's a specific issue, experience, or a tenant has a need of 9 months because of work, or some has to be there because of family taking care of someone just for 9 months, and something that shows that it will be just 9 months, then it's okay. But if in many cases it's not.
And they still say, I mean, I think people still did not understand, can we advertise an Airbnb or similar when renting for temporada in the winter? Of course. With license, I mean, I don't know what you mean here, Angeletta. With license. Well, if you already have a license for short term, sorry, for touristic, then you need to stick to it unless you tell them what dates are going to be different. Okay, so you could advertise either way correctly. So if you do Airbnb, you need to say it's more than 11 months, 11 days, sorry. If it's Airbnb with less, you need to have the license. And then if you do the mixture, you need to communicate what period of time is touristic and what period of time is long-term or short-term. Okay. So I don't know if it's clear, but as I said, one side, the other side, if you're right in the middle, you will need to be dealing with informing the period of time already programmed by you. And the communication needs to be done to the registry here, to the same registry where you apply for the license. And you've got it in the law here where I told you. Obviously, we're running out of time, but you have here, if you're doing it through yourself, if you do it through your lawyer, he will tell you. But where you communicate the touristic license, that's where you need to tell the calendar for the year. I mean, obviously, for those who wants to risk a bit more, could update that calendar and report it, you know. But it really requires an active communication between you and the board. I have an evidence, just in case somebody sues you, somebody denounces you, you say, no, I did inform about this. Paula is saying, if she understood correctly, yes, this is Pedro. This is at least it's my interpretation. More than 11 days, you could advertise it anywhere you like, but just make sure it is 11 days or more. Okay, you could publish it, but you could say you don't need to communicate that it's short term or long term. Okay, well, it will be very clear when you click on Airbnb booking. Could I book for 5 days in this apartment? It will not allow you to do so. So could I book 11? It will say yes. So it's a clear evidence that you're only booking for that. This is our interpretation nowadays of the law, even though before we close and wrap up, this is just a preliminary. We only have 1 month of this applicable law. We will do more webinars about updating about what's going on with this law, what is interpretation, and how we move forward. I mean, some of the questions you had is, do they have enough inspectors? Probably they don't, obviously. We all understand that. But if somebody of your community, somebody of your surroundings, somebody denounce your activity, then they will open a file against you. So it is important we all decide what we want to do from now onwards. Anything else, Pedro? Because we need to wrap up.
I think anything else for now. I mean, obviously, I can see there are so many questions to answer. I don't think we can. Sadly, we can't.
I still think people probably are not clear. If there are more than 11 days, you could have a contract. You could still do it through a platform. It's irrelevant. You could do it through a platform as well. You don't need a contract. I mean, it is an option, but you don't have to. This is Anto saying here. I mean, when you rent it out in the old days, when you used to rent it out for 20 days, you don't necessarily need a contract. Probably you want a contract, but you don't have to have a contract. It is up to you to have a contract. Probably it's not handy. It's not obviously for 6 months. If you want to have it, that's fine. But the Airbnb did allow you to do long-term, short-term, and touristic today. It is more about your responsibility on the license. This is what we want you to reflect, is if you're going to do this type of business, you need to comply with this law now. And this is the whole point today, is informing you that this law came into force and you need to update depending on your situation. If anybody has more questions, probably I recommend them to contact their lawyer or contact us eventually if they need assistance to do the same. speak to their surveyors, hire the surveyor. And the key point here for all of you and us is, now what? What do we do? And it is a very open market now to decide how you want to conduct your business from now onwards. Pedro, anything else?
Anything else? Thank you very much, everyone, to listen to us. Hopefully, we have clarified some doubts. We will be obviously getting into these new amendments that has happened, and obviously we'll be promoting that information really on our website. And hopefully, in a few weeks' time, we will probably make another webinar in order to some situation that we understand are not clear, in order to clarify and have a better understanding of this new law.
Okay. All right, Juanfran, over to you. See you hopefully in 2 weeks' time. And for those who missed a lot of information, just click on the live TV webinars and you'll have a lot of things over there. Over to you, Juanfran. Thank you.
Trust is vital when you're in another country. If you want to buy a home, set up business relationships, or apply for a residence permit, you need to be able to count on the best independent legal aid. Pellicer and Heredia is an international firm of lawyers with over 20 years' experience and one single aim: for you to live at ease in Spain. In order to give you a clear, streamlined, and fast response, we work with a cross-disciplinary team of professionals specializing in the main legal fields: civil law, foreigners' affairs, business law, tax and financial law, and international law. And to ensure that you're kept informed and up to date with everything, we have 6 offices on the Eastern Coast. Whether you're from here or abroad, we will always stand by you and speak your language. Our relationship is based on openness, professionalism, and a commitment to finding legal solutions in your best interests and for your peace of mind. Pellicer and Heredia, international lawyers.